Excellent. Well, first of all, thank you for the invitation. I'm planning to sort of go into some concrete detail about problems in the asylum system itself. Because, of course, from the responsible politicians, it is always repeated that everyone receives an individual and thorough, individuell og grundig assessment. While, in fact, the system is seriously flawed from the bottom up. My background for talking about this, I worked with asylum cases and asylum politics more or less since 1999 in different organizations. First in NOAS, later in Norwegian people say Norsk Folkehjelp for a little period, and now in the Norwegian Center Against Racism. It might not sort of be obvious to everyone that an organization like Antirasistisk Center should involve itself in asylum politics. I mean, where is the connection to racism here? But with the negative turns that have been taken repeatedly since 2003, 2004 in Norwegian asylum politics, it became obvious to us that we had to involve ourselves here. That's not indicating that, we're saying that the system itself is racist, but it is an indication or a reflection of the idea that, it's when we treat people as poorly as we often do asylum seekers, it is natural to ask if we would do this to everyone. When we accept an asylum system which is so flawed as is the case, we wouldn't accept that for other groups in society, basically. When you have a system, you have a process, a legal process, which is supposed to decide, basically over people's life, whether they will risk life or death in their country of origin and so on, the risk of torture. We would, there is no process similar in the Norwegian society, no other process that has the same kind of risks involved. And compared to the risks involved, the legal safeguards are amazingly weak. I will start by reminding you that the Norwegian Lawyers Association, Advokatforeningen, out of the 20 court cases they have taken against Utlendingsnemnda and against the government, they have won 14 of them. It's often mentioned that, from the side of the government, that these are just, 14 individual cases out of thousands, so it's not a lot. That is a very false view of this. Advokatforeningen have specifically chosen cases that have some principles involved, cases that reflect a larger number of cases. So behind each of these 14 cases they have won. There are tens or hundreds or even sometimes more of cases somehow similar that should have been influenced by the fact that the court has decided against Utlendingsnemnda here. So those 14 cases, all of them, I think, more or less, indicate some kind of flaw, different flaws with the asylum system itself. Talking about rettssikkerhet, I can hardly find exactly the same phrase in English, but the idea of legal safeguards, the idea of fair and proper treatment. How to define that? I would define it very, very simply. The fact that when you come as an asylum seeker, you should be able to expect a fair and more or less correct decision. A decision which is factually correct. Factually correct based on what the story you're presenting and what is known about the country you have fled from. You cannot expect that the government will never do mistakes, but you should be able to expect that they will do their utmost not to make mistakes. Of course, that is far from the case. I would sort of roughly divide the problems with the asylum system into 3 different categories, and I'll talk a bit about each category. One is the fact that a lot of the asylum system has been politicized. It's always been like that. It's not just a matter of facts and a matter of law, it's a matter of politics. But even so, over the last years, ever since Erna Solberg was minister and since then the Labour Party, we've seen the asylum field being even more politicized than before, directly affecting a lot of decisions. A second problem is sort of specific problems with the procedure, the asylum procedure itself. The third problem, it goes more into sort of what you call in Norwegian skjønnsvurderingen, the assessment, the reasoning of the caseworkers working in the UDI. So those 3 three different kinds of problems: the politicization of the asylum system, problems with the procedures, the formal procedures, and problems with the actual reasoning involved from the caseworkers. Of course, I have to point out that a lot of asylum cases are handled just the way they should be. There are quite a few asylum seekers who do get a positive decision. And usually I don't get to read those cases. Those who get a positive decision would never come to us. But way too much is also handled in an unacceptably poor manner. And just as a starting point to remind, when everybody's talking about how from the government side, how solid this system is, just let us remember as a starting point what the asylum system is supposed to do. Caseworkers who have usually never been to the countries people have fled from, who certainly do not speak the language in that country, who cannot read the newspapers in that country, are supposed to speculate on how torturers and hangmen on the other side of the globe will react to this individual. As an intellectual challenge, it is not only daunting, it is completely almost irrational to try to do this. To think you can actually just foresee, okay, this asylum seeker will be tortured, but this, nah, probably not. It is a more or less sophisticated, not always so sophisticated guessing game. But you'll never see the government actually admitting to this, but they are involved in a task which really is impossible and which would demand a lot more humility than you would see. You will often hear from the government that those who are rejected are not in need of protection. There are no qualifications, no humility. The speculation that has been done in the decision is treated as written in stone and as solid and undisputable facts. The Secretary of State responsible for this field, Mr. Paul Lancet, has said that he's read a few of these cases, and he says that the rettssikkerhetsnivået, the level of legal safeguards, the quality of the treatment is almost as high as in criminal cases. I really hope he's wrong, because if he is right, a lot of innocent people are in prison. But only just on the surface of it, the comparison is amazingly uninsightful. If you steal something, if you commit a rape, if you rob a bank, if you kill somebody, if you kill 77 people, you will get to meet your accusers, you will get to meet the people who will decide your case. If you're an asylum seeker, you don't. Just as a sort of basic point, anybody who steals anything has better legal safeguards than an asylum seeker can expect to. An asylum seeker can go through the entire asylum process without ever meeting the persons who decide the case. And to even indicate, to pretend that the level of rettssikkerhet, the level of legal safeguards is high and satisfactory is to me quite appalling. Going into sort of the first of the three problems that I mentioned, the politicization of the asylum process. To some extent that is unavoidable, that politicians will want to have a say in things. But what we've seen recently, partly under the former government, but particularly under this government, is that the government will instruct the authorities on how to treat certain groups of asylum seekers. We, for instance, had instructions about how, that the UDI has to be tougher on Iraqis, they have to be tougher on Somalis, directly from the government. These instructions will be like 1 page long. They are completely contrary to the UN guidelines. The UN guidelines are not even mentioned in these instructions, and really there is no justification. The government says, nah, I think we have to be a bit tougher against certain groups coming from the central parts of Iraq. They're not saying why. They're not giving any reasons why they think that is right. They're just using their power to say, now the UDI has to be tougher. And to me that's a kind of it's an example of a really poor management of any system, really, where the ministry can just decide that it should be like this without ever having to offer any kind of clarification. When they're saying that this group of people should from now on be rejected, but they're not saying anything why. Why is the UDI wrong? The UDI would want to grant the cases, but they're no longer allowed to. The ministry doesn't have to say why the UDI were wrong. They're just saying reject, reject, reject. You'll also have, coming from the government itself, and this is maybe a technical point, but it's kind of an important one as well. You'll have from the government coming an instruction, to the UDI saying that when you consider if somebody should have a residence permit on humanitarian basis, you cannot look to the general situation in the area somebody has fled from. You cannot, considering people fleeing Gaza or the West Bank, you cannot consider the general living conditions. Or somebody fleeing Mogadishu, you cannot consider the general living conditions. You have to look at that specific person, the problems that specific person has. The fact that some of these areas are more or less uninhabitable, that there might be a general risk for everybody. No. The UDI is not allowed to, in some cases, to take that into consideration. And with that kind of instructions, it's a very technical one, but it's a technical instruction which really changed a lot. Because before, in the early years, it was normal that quite a lot of people would get humanitarian residence permits. Like many people from Palestine would. They would also get other kinds, but they would also get humanitarian based on the general conditions. But the government decided that no, it doesn't make any difference how bad the general conditions are. Reject, reject, reject. Alongside this kind of negative policy developments from the side of the government, you find a lack of interest in ever seeing the asylum seeker's perspective, which I think is worse than before. I mean, when I started working with asylum politics back in 1999, we would actually have meetings with the government, with the ministries. There was meaning to having meetings with the ministries and saying, this part of the system isn't going so well. The interviews are not being done in the proper manner. Maybe you should look at, trafficking victims, how they're treated. And they would be interested in doing something about it. The idea now of actually seeing the problems of the asylum system from the side of the asylum seeker seems to be almost, not entirely, but almost completely absent. The idea that, the asylum seeker has an experience of the system, that, any system has to be continually improved. That idea seems to be gone over the last decade when in regard to the asylum system. There have been no major reforms of the asylum system that I can think of. A lot of restrictive policy measures, but nothing in regard to how people are interviewed, how information is collected and so on, how cases are handled formally. No real improvement and not much interest for improvement either. The other problem that's sort of continuation of that. The other problem area I mentioned was problems with the procedure. And there are quite many. I mean, the problems will begin already when you register as an asylum seeker with the police. And that's not one of the major problems. There aren't that many asylum seekers who get a lot of problems because of the police registration, but it happens. One basic problem is you'll have an interpreter over the phone, maybe quite late in the evening. The police are interested in their own things, not necessarily the things which will be of interest to the caseworkers later, so they write things down quite hastily. I've seen examples of that lately. One example I'm thinking of in particular, where very clearly the problems that arose later in the asylum case was based on the fact that the police officer did a 5-minute registration. He didn't actually ask the questions the way he wrote them down, and a lot of misunderstandings would pop up. But that very first contact, already then you risk having problems if some details are gotten wrong. If the interpreter over the phone gets some details wrong, you'll have problems. The problems might continue with the asylum interview with the UDI. Now, my impression is that the interviews have gotten a bit better. I don't work with cases on a daily basis the way I used to, so I'm not really able to give a complete judgment of the interviews as of now. But what I've seen is better, but still often too flawed. And here one of the problems is often that, sometimes the interviewer and the decision maker might be the same person, sometimes they're not. So you'll have the interviewer asking questions which really are not what the case decider would be most interested in. Like one of the things which for years and years and years has annoyed me in many UDI interviews is a very common problem in asylum cases. Cases where somebody has been recruited to an illegal organization. This is the case in many countries. I worked a lot in Ethiopia. It's one of the most common things. That's basically the asylum claim. They've been active for be it for attached to Ginbot or to EPRP or to OLF, some illegal institution. Then, of course, it's always a question, how were they recruited? You know, it's one of the most basic things to ask about. But in case after case after case, you will find the same thing. The interviewer never really asked. You might have noted down in an interview that, well, I was approached by someone who spoke to me about the OLF, and you know, after a while I joined. I've never seen an interviewer asking, so how long did you know this person before he mentioned the OLF? Because OLF is very dangerous to mention. So you know, if you meet somebody on the street in Ethiopia and he starts talking about OLF or EPRP or Ginbot, that would be fairly insane because it is dangerous. But you'll never see an interviewer asking about that. How long did you actually know this person before he trusted you? However, what you will see in the decisions, a lot of decisions for Ethiopians is, no, we don't believe the way you were recruited, because why would some stranger trust you? Well, the UDI never found out if the person who recruited you was a stranger. It is, again, a kind of a detail, but it's a very common problem in asylum cases, and it baffles me that the UDI, year after year after year, they don't ask in the interviews what is crucial when they reject the cases afterwards. Then, of course, they have the problems again of the interpretation, and it's difficult to say how often the interpretation is damaging to asylum seekers. But what I would have to say is that my impression is that any kind of problem that arises with the asylum seeker's explanation is the asylum seeker's fault. Everybody else is perfect. The caseworkers ask perfect questions, the interpreters translate everything perfectly, and the interviewer writes it down perfectly. Any mistake is from the asylum seeker. You know, it's like they completely forget that there are some other humans involved there, and the fact that the interpreters probably make a solid dose of mistakes in every interview they make. It's funny sometimes when you can actually follow the mistakes made by the interpreters. Like I was in a meeting in Utlendingsnemnda where it became so clear that the interpreter was lousy. And it's good when they're really bad, because if they're really bad, even the judges will notice. If they're just moderately bad, nobody will notice how bad the interpreters are. But this one was really bad. And there was one, an Ethiopian who was talking about that they had been protesting in demonstrations. So then the judge asked, so how did you protest? Did you go i tog, which means in Norwegian to go in a procession. Tog also means a train. Then the answer, so that's the question of the judge. So did you go in a tog, a procession? And the asylum seeker answered a bit baffled, translated to, no, we did not use a bus in the demonstration. Which means, you know, the interpreter had completely misunderstood, you know, the word tog. When it's as clear as that, or another example I remember, where we had a translator doing a written translation, and he translated the United Nations as the USA. You know, sometimes they might seem similar, but United Nations are not the same as the United States of America. You'll have a lot of these mistakes, and I think more or less in every case. But these mistakes are invisible. If there are mistakes, they're always the asylum seekers. Another very basic problem is the lack of legal safeguards for torture victims, which to me is also one of the most amazing things to see. Torture victims, people who might have actual damages, scars from torture, will not get any help to document these injuries. They will have to do it on their own. They'll have to find some doctor who has no expertise on torture wounds, and you'll see some little statement like this about what the scars look like. There is nothing systematized in regard to actually documenting people who have torture wounds. I would think that torture victims would be really one of the most prioritized groups within the asylum process, but they clearly are not. This continues in the actual decisions. You will find that the torture people have experienced is often toned down or even ignored in the decisions. You'll have, one example is, I'll read this. This is what an asylum seeker. I've used this example before, and it's one of the worst examples. But you know, there are many cases, although not as bad as this, quite similar. This is what the asylum seeker told in his interview. He was from Ethiopia. I was beaten on a daily basis by different men who came in groups and abused me. My whole body is full of torture marks. I was tortured with electrical wires. I was burned with glowing barbed wire. They burned me with barbed wire also on my penis. All kinds of suffering that human beings should not experience or even see. I longed for death. I was hung up naked. I was burned with glowing wire and I was beaten. Look at my behind. Look at my penis. Not even animals are treated like this. What kind of people will do this to other people? I feel worthless. I complain over the day I was born. Now, what does the UDI do in the decision? They reject it because he was only in prison for a short period of time. This is actually written in the decision, and I will now quote from the UDI. Direktoratet viste til at søker kun var fengslet i en kortere periode. The torture was not mentioned. And this also goes a bit into the assessment of the cases, which is my third topic. But the fact that torture is almost systematically toned down. In case after case where people have been abused in prison, where they have been tortured, the torture will, well, maybe it's mentioned briefly in the start of the decision, but when you come to the rejection and the reasoning why the UDI and the appeals board have rejected the case, the torture suddenly has disappeared. And the imprisonment was short. And because it was short, it was not persecution. Legally, of course, it's completely unacceptable. Torture is always, without exception, persecution under international law. Back to the problems of the procedure itself. And yet another problem is the limited access to legal aid. You need a lot more hours to actually go into a case and to do the kind of examination you need to than the few hours given to lawyers. Of course, it's also a problem that the lawyers, even when they had more time, didn't really do a very good job. There was an assessment of the assistance given by lawyers in asylum cases, where the evaluator wrote that the lawyers have an odd tendency to not focus on the essential issues in the case. And that's basically my assessment as well. Maybe 20% of the legal aid is actually of the quality it should be. That would be a maximum. Then, of course, one of the main problems with the procedure, with the asylum procedure, is Utlendingsnemnda as such. There are so many problems with Utlendingsnemnda that I would hardly know where to begin. But the most obvious problem is what I hinted at earlier, that people would usually not actually ever be in the same room as the decision makers. Like 10% of the cases end up, being treated with the asylum seeker actually being allowed to come to Utlendingsnemnda and tell their story. That was never the idea behind Utlendingsnemnda. The first year of Utlendingsnemnda, the budget indicated that half the cases should be treated with the asylum seeker coming into the meeting. Half. It's 10%. You have a lot of other problems. You have the problem of the people who sit and handling the cases in Nemnda having way too little time to actually read the documents. You have lay members, you have the employed judges, they have all the time they need. The professional judges who tend to be of a restrictive approach, they can use the time they want to. But the lay members, the normal people who come into the side cases, their time is limited to the 3 days they are actually in Nemnda. Asylum cases can be complex. You can have case folders this thick, but they still only have 1 or 2 or a maximum of 3 days to actually go into this. You also have basic problems of asylum seekers not being told, not being informed about examinations done of their cases. I'm working on a case right now, which is a decision from 2004, an Ethiopian as well, who he was active for a political party, and Utlendingsnemnda has found out that this party never existed in the country where he was. He was not in Ethiopia, he was in another country. let's say he was in Sweden. He wasn't in Sweden, but let's say Sweden. Utlendingsnemnda says, no, you were not active in Sweden because your party never existed in Sweden. Then they write in the decision that, because we have spoken to your party and they say they never had a section in Sweden. Now, there are so many mistakes in the handling of that case. First of all, when Utlendingsnemnda talks to his party, he has a legal right to know. Under the forvaltningslov, the law which governs all of public administration in Norway, if they collect information about his case, he needs to get it. He didn't get it. The first time he saw this negative information was in the decision. That's the first mistake. In the decision, they don't name who they have the information from. They say his party. They don't give the names of the people. Second mistake. Of course, you are entitled to knowing the sources of information. As if the sources are in danger, yeah, that's one thing. But in this case, the sources were in Norway. Utlendingsnemnda had spoken to Ethiopians in Norway. Ethiopians in Norway are not in danger. They could have put the names there, but they didn't. Second mistake. Complete disregard of forvaltningsloven, which is the basic law governing Utlendingsnemnda. Third mistake. I spoke to one of their sources, who said he was completely misunderstood. He had never said there was no such section in Sweden. There was some confusion about terminology, but he had never said that. This was 8 years ago. For 8 years, this man has been living in Norway, having been rejected based on Utlendingsnemnda talking to a source they never specified, a source they never presented to the asylum seeker, and a source who never said what they claim he said. 8 years. He has lived in Norway with a decision based on bad facts. Because, of course, after the negative decision from Utlendingsnemnda, you get no more assistance. You will not get a lawyer to help you. So if I had by accident come into his case, nobody would have looked into this. Nobody would have located the actual source Utlendingsnemnda used against him and found that the source never said what they claim. I need to of course, there are so many things to say about this, and I can't take all afternoon. But just to conclude on Utlendingsnemnda, presently, and I think this is one of the most important things, and one of the most important things to work with. Presently, Utlendingsnemnda has a lower level of legal safeguards than any of our neighboring countries. Sweden, Denmark, Finland, they all have substantially stronger legal safeguards. In all of these three countries, asylum seekers are usually allowed to meet in person. That is a norm in our neighboring countries. Norway, 10%. In all of these three countries, you have a two-part process, which means that, it's a bit difficult to explain, but you have more of an open process where both parties meet. The asylum seeker meets, and the Directorate of Immigration should meet before the appeals board. So that you can really delve into, well, why did the Directorate of Immigration reject your case? That they can actually be challenged more thoroughly. In all of our neighboring countries, you have these legal safeguards, not in Norway. We just had a committee which sort of proposed how to improve Utlendingsnemnda. If we do all the things they suggested, Meranutvalget as it's called, if we do all the things they suggested, we still will have substantially lower legal safeguards than in all of our neighboring countries. I think that is one of the most crucial things to fight for. We have to have a new appeal system where, as the main thing, asylum seekers have to be allowed to meet in person the people who will decide their future. And right now, as I said, there was a committee who considered this, but politically nothing is happening. Politically, the case right now is dead. There's no interest, I think, as far as I can see, in the Labour Party and so on, to actually reform Utlendingsnemnda, even though, their own committee suggested some reforms. So if we're going to get anything to happen here, we need to work quite hard. But I do think it's really one of the most important things to change. The third and final topic that I mentioned, the problem areas, is the assessment itself. The assessment done by the caseworkers in some of the cases. And the problems with the assessment are related to really all the basic areas of any asylum case. One, of course, is all the accusations against the credibility of asylum seekers. There are so many decisions where people are rejected because the caseworkers find that what they've said is, it's a bit strange, you know. They use words like påfallende or påtagelig in decisions. It's a bit strange that you would drive, when you fled from Grozny, you would drive that way and not that way. As if we always make the right decisions about where there is less traffic. Particularly when you flee a war zone. But I've seen people who have been rejected because they chose a different road than you should have done. You'll have, I remember one case which was, to me, one of the worst. I remember one case where a woman from Kosovo a knife was held against her throat. Her 5-year-old son was sleeping in the bed next to her, and while she was being raped, under threat that they would kill her and her son. And Utlendingsnemnda and UDI rejected it because they thought, no, it's an unlikely story. That's all. It's unlikely that would happen. You know, why would somebody do something like that to another human being? It's like some kind of innocence in regard to, you know, basically the evil that happens in this world. You can read any number of books on Kosovo and Bosnia, and you'd find a lot of stories like this. But she was rejected because they thought it was, usannsynlig. Seriously, that's why she was rejected. You'll have other people who are rejected because they've been tortured and then brought to a hospital. No, that's not likely. If they torture you, they will bring you to hospital. Even in the concentration camps, there were doctors that actually sometimes would also help people. You know, and the idea is that the world is somehow A4. It's very simple, it's very predictable. If you torture somebody, you don't bring them to the hospital. Well, you do sometimes. If you torture somebody so badly that if you don't bring them to the hospital, they'll die, and you want to interrogate them more tomorrow, you bring them to the hospital. That's one example. Another central example, I think, of really one of the basic issues, which is also a debate going on in Dagsavisen now, is how female asylum seekers are often treated. You'll have, and this is a problem in several countries, but again I worked most with Ethiopia, I worked with Ethiopian cases since 2003, and this has been a problem all along. A lot of Ethiopian women, I have to say, tell that they have been subject to sexual abuse by the Ethiopian regime, by police, often security police. And in case after case after case, they will be rejected. They will be rejected because the UDI and Utlendingsnemnda think that this is not persecution, these rapes are just acts of crime. There is an area of fairly basic misunderstanding or misconception about rape as an actual act of torture. The fact is that if the torturers in the Ethiopian torture cells decide other modes of torture, the women might not be rejected on this basis. You know, if they are only beaten, if they're only whipped, then they might not say that. But as soon as the rape enters into it, the rape covers everything. No, it's no longer persecution, it's no longer torture, it's just that one torturer who did this because he wanted to. He didn't act on behalf of the regime, he did it because he felt like doing it. You have tens of Ethiopian women, maybe more, who have been rejected on that basis. I've even seen cases where the woman has been beaten, whipped, beaten with different instruments, and in addition raped. And suddenly, because of the rape, everything is acts of crime, and nothing is persecution. Even the actual standard torture suddenly becomes invisible. It's no longer persecution. I've already mentioned one of the, and this is, as I said, it's a basic problem, you know, for affecting quite a lot of women. Another basic problem is the one I hinted at, the problem of the fact that they generally tone down torture in a lot of cases. You'll even have cases where they say, oh, we don't believe that you were ever imprisoned and tortured, where the person might have torture marks all over their body. But hey, they never got any help to documenting it, so you know, the UDI and Utlendingsnemnda never need to actually consider it. They'll just forget about it. It might be mentioned in the interview that, you know, I have these wounds all over my body, but when it comes to considering whether they were actually ever imprisoned and tortured, the UDI and Utlendingsnemnda would sometimes forget completely about the fact that there is some physical evidence here. The last thing I thought I would mention in regard to sort of problems with the assessment of cases, problems with the reasoning involved, is the reasoning related to the so-called innvandringsregulerende hensyn. Innvandringsregulerende hensyn is the idea that we need to limit immigration to Norway, which means that, as many of you know, a case which should have been granted, a case which is strong enough to be granted, is rejected because really we don't want more people coming. That is basically what it means. Of course, I'm not going to say it's completely legitimate to somehow limit immigration every now and then, but the way this is used has at times fairly horrific results. An example I would give is a few years old, but I sort of think we should not allow ourselves to forget about it. That was back in 2004, I think, where a little girl from Kosovo, Gresa Kortsai, I think she was 6. She had 7 or 8 afflictions, from cerebral paralysis to what you call vannhode, waterhead, partly blind, partly deaf. She was an epileptic. Basically, she probably would not have that long to live anyway. In Norway, you know, if you're worried about immigration, she wouldn't have been among us very long. In the statements from her doctor, it was stated that if she does not get the proper treatment, there are 2 risks. One is death. She might, on short notice, need sophisticated surgery. Was Kosovo in 2004 a place for sophisticated surgery? Not really. The other was that without proper treatment, she would experience, she would grow in a contorted way and experience more physical pain. So we rejected her case. And I'm saying we now, because, you know, these institutions are acting on behalf of Norwegian society. We rejected her case, knowing full well that it meant higher risk of death and a higher risk of physical pain for a 6-year-old girl. The case was clearly strong enough to be granted, as Utlendingsnemnda would admit, but innvandringsregulerende hensyn, we don't want more very afflicted children like that coming to Norway, so we have to reject it to protect the Norwegian society. So we rejected it, deported her, and a few months later, of course, she died. That is one of the worst cases I know about. And of course, when I'm talking about that again, I should again highlight that it's not representative for everything that happens in the asylum system. But this also happens. And it really shouldn't happen. There really should be... You know, there are asylum cases where it's difficult to assess. There are people, sometimes when I don't know if I believe people. That happens. There are cases that are difficult. This is not difficult. We should not send small children back to more physical pain and higher risk of death. That is not difficult. Let's leave what's difficult but this is not difficult, and it should never be difficult. It's of course the same argument which is used against the people who have lived there for a long time without a residence permit. We now have one man you might have heard of, Yamala, who has lived in reception centers for more than 20 years. And of course there are strong enough humanitarian reasons to grant this case. Of course anybody who wants to understands why nobody goes back voluntarily to Eritrea. But again, the risk of further immigration, the risk of other people like Imana wanting to live 20 years in a reception center, it's not a big risk, but we really don't want more people to come, so even this small risk means we will reject his case repeatedly. The same, of course, in regard to the children. That is the very last thing I will mention. We do have in the law fairly good rules in regard to children who are often born and brought up in Norway, who live in Norway for several years. It is stated clearly that these children, more weight should be given on their attachment to Norway. When they are rejected, it is always more or less because of innvandringsregulerende hensyn, because we don't want more people behaving like this, we don't want more people coming, and so on. So you will have decisions for people who've been in Norway, children who've been in Norway for 7, 8 years. And again, utlendingsemda writes, it's humanitarian considerations would, should lead to a residence permit, but really we have to put more emphasis on avoiding immigration, so we will reject the case. That was all I was planning to say. I think that's more than enough. And I noticed when I'm talking about this, I think my tone of voice, I think some anger seeps into it. I don't want to demonize the asylum system, because as I've said a couple of times, what I mentioned now are some of the worst examples. But these examples should never take place. And that's sort of why my main concern is, it's not the caseworkers who sometimes do a poor job, or some of the caseworkers who most of the time do a poor job. My main concern is the lack of interest politically in seeing the flaws of the system. Any system, any state system will always to some extent be flawed. You have to continually be open to criticism and be interested in mending the flaws. Right now, I see no such interest among the responsible politicians, more or less. And that is, that is sort of the part that could be demonized a bit. That is sort of, the main thing that deserves criticism. Not every caseworker who does a poor job, although some of them deserve the criticism. But the responsible politicians who really should be able to see some of the really basic problems a lot of asylum seekers face. Yeah, thank you.